Hello friends, welcome back to the series of lecture. This is the 34th lecture of this series of Indian Evidence Act. In the previous lecture we had started with section 9, then we discussed the TIP, then we discussed relationship, and there we have talked about section 32 clause 5, 32 clause 6, then section 50, फिर उसके बाद DNA test उसके सारे dimensions we have discussed, and in same process we have discussed section 112 and section 4. And whether the DNA can override the presumption of section 112, then may presume, shall presume, etc. we have discussed. And then somewhere we have shifted to expert evidence. Expert evidence में we have discussed section 45 till 51, including section 13 and 32 clause 4 and 7. Then from there we talked about narco text. Then after narco we also talked about audio video. Then we also talked about other kinds of experts. अब अदर काइंड ऑफ एक्सपर्ट्स में रिसर्च करने की ज़रूरत नहीं है बिकॉज देयर इज डिफरेंस बिटवीन एकेडमिक्स एंड एग्जाम्स, जुडिशियरी एंड कॉलेज एग्जाम, कॉलेज एकेडमिक्स. अब जैसे बैलिस्टिक के बारे में पढ़ा था हमने, तो यू मे फाउंड अ बुक अपॉन बैलिस्टिक एक्सपर्ट. सो इतनी मोटी किताब मिल जाएगी आपको बैलिस्टिक साइंस का ही, तो उसके पढ़ के रिसर्च करो, दैट इज़ नॉट रिक्वायर्ड. जब आप जज वगैरह बन जाओगे, जैसे दिल्ली वगैरह स्टेट में है, तो उधर फॉरेंसिक लैब वगैरह हैं, तो दे विल ट्रेन यू फॉर दैट. बट फॉर नाउ यू जस्ट टू नो द एडमिसिबिलिटी एंड रिलायबिलिटी, उस पर रिसर्च नहीं करना. देन वी हैव लुक्ड अपॉन द इंक्वेस्ट एंड द पोस्टमार्टम का डिफरेंस. अब नाउ वी हैव टू रिवर्ट बैक टू द सेक्शन 9. देयर आर सर्टेन phases in the section 9 which is still remaining, so that has to be completed. Likewise, if you see that how broad this topic is, हम चाहते तो 112 वगैरह अलग से भी कर सकते थे, but that makes the topics very flat. So जो not only the topic wise linking but the spirit also linked, so that should be normally be done together. Now after that you are left with certain terms in section 9, and out of them one is fact which support or rebut. जो सेक्शन 9 के रिमेनिंग टर्म्स हैं उनमें से वन है फैक्ट विच सपोर्ट और रिबट. सो इट इज़ अ वेरी सिंपल टॉपिक. सपोर्ट और रिबट द इन्फ्रेंस suggested by some other fact. A fact which support or rebut an inference suggested by some other fact. And then you also have the facts which explains or introduces the relevant fact or fact in issue. And another is facts which establish the time and place of occurrence. Facts which establish the time and place of the occurrence. And these are very common sense kind of things. अब section 9 निकाल लीजिए. Section 9, fact necessary to explain or introduce a fact in issue or relevant fact. That is one point. Facts necessary to explain or introduce a fact in issue or relevant fact, or which support or rebut an inference suggested by a fact in issue or relevant fact. Which support or rebut what? An inference. An inference suggested by a fact in issue or relevant fact. तो इन सब में एक एक एग्जाम्पल देखना है हमें. लास्ट में दे आर सेइंग फैक्ट्स विच एस्टेब्लिश द आइडेंटिटी के बाद, और which fix the time or place at which any fact in issue or relevant fact happened. So any fact which fix the time or place at which any fact in issue or relevant fact happened will be relevant. अब ये टाइम और प्लेस के लिए कोई एग्जांपल सोचो. अब सपोज देयर वाज एन इंसिडेंट, सपोज देयर इज एन एलिगेशन दैट A killed B. अब you do not know the time. Now you see that there are some watches which work on your nerves. आप उस घड़ी को हाथ में बांध कर रखोगे तो वो चलती रहेगी on your nerves. जैसे ही उसको उतारोगे वो बंद हो जाएगी. रिस्ट में पहनोगे तो चलना चालू हो जाएगी, उतारोगे बंद हो जाएगी, फिर दोबारा टाइम सेट करो जब पहनना हो. तुरंत नहीं बंद होती. इट मे टेक्स 5-10 minutes to stop. अब सपोज्ड दैट B was wearing such watch which works on your nerves. अब the time showing in that watch is 10:10 p.m. उसके हाथ में मृत है ये बी, उसके हाथ में घड़ी बंधी हुई है और उसमें ये टाइम हुआ है, घड़ी बंद हो गई है। अब इसका मतलब क्या है कि उसकी डेथ 10:10 पर या फिर उसके 10-5 मिनट पहले हुई होगी। तो ऐसी वॉचेज एकदम तुरंत बंद नहीं होती, उनमें टाइम पीरियड होता है 10 मिनट 20 मिनट, कई में आधे घंटे का भी होता है। सो इट विल कैलकुलेट कि अगर घड़ी 10:10 पे बंद हुई है एंड इफ द वॉच सस्टेन्स फॉर हाफ एन आवर विदाउट द रेस्ट then he may have murdered on 9:40. So in that way you can find out the time. So there are similar incidents, similar examples which can be the basis of finding of the time of the incident occurred. अब जैसे मरने वाले ने मरने से पहले कहीं लिख के मरा कि दैट इतने बजे मेरे को शॉट किया ए ने, 8 o'clock ए शॉट अपॉन मी, जस्ट एन एग्जाम्पल। अब प्लेस के लिए एग्जाम्पल देख लेते हैं। अब सपोज a person dead body found inside a graveyard. ग्रेवयार्ड में कोई मृत व्यक्ति को छोड़ गया, उसके सारे कपड़े उतार लिए उसने। The dead body is completely naked. Only one shoe was left near the body. ग्रेवयार्ड में एक जूता रह गया गलती से। And there are some signs of tires of car. जो आई होगी उधर उसको छोड़ के चली गई होगी। अब पुलिस को इन्फॉर्म किया गया, पुलिस की उस व्यक्ति को गोली लगी थी। उसके बाद पुलिस ने इन्वेस्टिगेशन किया। अब यहाँ पर कहीं पर एट दिस प्लेस देयर इज सम डिस्टेंस फ्रॉम द ग्रेवयार्ड। अब सपोज मान लो वो व्यक्ति यहाँ पर रहता था, दिस हाउस। अब लेटर ऑन व्हाट वाज फाउंड दैट व्हेन द डॉग वाज बॉट and dog smelled, investigation gone, that when the police raided that house, so when police raided that house in the last room of the house, so in the inner part of that house a lot of blood etc was found. अब उसी afternoon में the police raided because the police know about that the body immediately. Now you see the dead body was found here, then how the police establish the place of occurrence. घटना कहाँ पर हुई है ये पुलिस ने कैसे एस्टेब्लिश किया? By the dog tracking. Then the dog smelled and ran into that direction of the house where the murder occurred. So somehow dog went to the car तक पहुंच गया and somehow the police officers went inside and found the other shoe. The other shoe was found in that room. The blood-soaked dress was found in that room. हो सकता है उन्होंने अभी मर्डर किया हो या सब रात को मर्डर किया हुआ और डेड बॉडी को फेंक दिया होगा, कुछ भी एविडेंस डिस्ट्रॉय ना कर पाए हों ताकि स्मेल ना आए डेड बॉडी घर में, और गलती से जूता उठाना ग्रेवयार्ड से भूल गए थे, अदरवाइज कपड़े वगैरह सारे हटा दिए थे। अब द फैक्ट इज व्हेन द ब्लड वाज एग्जामिन्ड, द ब्लड फाइंड इन द रूम वाज मैच्ड with the blood group of this man dead body. The other shoe was found in the same room, and the family members of the dead body's family gave the evidences of that the dishes were found in the room is belonging to him. Then all these evidence is not suggesting that the crime was committed in that room. So is it not the place of occurrence of crime? So this kind of evidences may suggest that where the crime was committed. अब मान लो ए और बी के बीच में झगड़ा हुआ और जिस जगह पे झगड़ा हुआ वहाँ पर they will find there were founding of the marks of fight. Now you talk about the Santosh Singh case. In that case, the place where the entire incident took place, the visor piece was found there, the heater wire found there, and so on and so forth. Then is that not suggesting that the crime was committed in that very room? Now these are what? These are the effect of the crime. Section 7 में relevant होगा effect, लेकिन effect की वजह से place of crime will also be relevant. अब you must appreciate कि जरूरी नहीं एक fact एक ही section में आए, एक fact एक से ज़्यादा सेक्शंस में, एक से ज़्यादा टर्म्स में ओवरलैप कर सकता है। सो वॉट एवर मे बी द इफेक्ट ऑफ अ क्राइम, अब जैसे ब्लड फाउंड इन दैट रूम, जो मर्डर वाला एग्जाम्पल देखा, अब ब्लड वॉज द ऑब्वियसली द इफेक्ट ऑफ द क्राइम, द क्लोथ्स, जो ब्लड सोक था क्लोथ्स में, दैट वॉज द इफेक्ट ऑफ द क्राइम, and that was all there, and that went to prove that that is the place where the crime is committed. Similarly in the Santosh Singh case, similarly in the RUC case, that Hemraj was killed in the house only, that was suggested by the fact that the blood from the body was found, that is on the stairs. If he was killed on the terrace, then why should the blood was found on the stairs? So obviously he was killed downstairs and he was carried. Maybe he was half alive at that time. He may have finally died on the terrace, but the injury was caused to him in the house itself. So that will go on to prove the place where the crime is committed. Now shifting from there, there is another term. I hope you are jotting down these points. इसमें कुछ dictation नहीं है. Now another term is any fact which supports or rebut an inference suggested by a fact in issue or relevant fact. Any fact which supports or rebut an inference suggested by a fact in issue or relevant fact. अब you see, एक एग्जाम्पल लेते हैं इसमें. अब मान लो these are two houses. Now here the theft was committed at night. It is the house of B and theft was committed in one night in the house of B. अब A on the same night, from the same night was found to be missing. उसी रात से A गायब है. And he did not come back for 4-5 days. 4-5 दिनों तक A not came. He was not present. Tell me, after looking A's conduct, his conduct of absconding from the place, A's conduct from absconding from the place, is not that conduct a relevant fact in the sense of being a subsequent conduct? मान लो एक ऊपर एलिगेशन है कि उसी ने चोरी की है. Now is it not the conduct of A absconding from the place relevant under subsequent conduct? Yes. Now this conduct suggests an inference. The conduct of A of absconding from the place is suggestive of an inference that he may have committed the offense. Thereafter A come back after 4-5 days, and he proves into the court that I have a factory at Dehradun. Suppose the incident took place at Delhi, and he proved that I have a factory in Dehradun. And in Dehradun, in that factory on that evening, there was a fire. And I received a phone call from the manager there, and I rushed to the Dehradun immediately. And I took 4-5 days to manage the affairs there, and now I came back. Now tell me, is that not the fact he went to the Dehradun factory because of the situation of the fire? Is it not rebutting the inference that you are drawing from his conduct? What is the inference you are drawing? That he has committed the offense. क्योंकि वो गायब हो गया, तो that is he committed the offense, that the inference you are drawing. But he proves that I went to the Dehradun factory because the fire was caught there. So ये जो fact है, this is going to rebut the inference, and therefore under this section it will be relevant. अब इसी को दूसरे शब्दों में कह सकते हो that this fact explains. अब यहाँ पर rebuttal और explanation दोनों overlap कर जाएंगे, क्योंकि इसमें एक है a fact explains or introduces. अब यहाँ पर his conduct of running away from Delhi, that is suggesting the inference that you may have committed the offense. Now the fact that the Dehradun factory was in fire, that explains to why is that conduct going off from Delhi, and that conduct is a relevant fact. So जो देहरादून वाला incident explains his conduct of going away from Delhi, and at the same time it rebut the inference that he may have committed the offense. तो ये दोनों में ओवरलैप कर रहा है, एक्सप्लेनेशन वाले में भी और रिवर्टल वाले में भी। इस एग्जाम्पल में ओवरलैप कर रहा है। अब बड़े ध्यान से सुनिएगा, यहाँ तक तो समझ गए होंगे आप। अब मान लो कोर्ट में ही हैज टू प्रूव एविडेंसेस टू रिवर्ट द इन्फ्रेंस, then he will prove that I was in the factory in Dehradun. He will prove from newspaper reports or maybe any other reports that the factory has caught fire on so and so date. And he will also prove that I was present there in the factory and the very next morning. The very next morning I was there. It is also proved that I was present in the very next morning in that factory. Of these three things he had proved. Is it sufficient for rebutting the inference, or will he be required to prove also that when you establish the factory, how many workers are working in the factory, how much income tax return you have paid for the factory, what is the product that you make into the factory, what is the income profit that you make from the factory. तो ये सारा डाटा भी प्रूव करना पड़ेगा, या फिर सिर्फ ये कि मेरा एक फैक्ट्री है और उसमें आग लग गई थी और अगले दिन सुबह सुबह मैं वहां पहुंच गया था, और दिल्ली से देहरादून में 6 घंटे तो लगते ही हैं, ट्रैफिक होता 8 भी लग जाते हैं। अब ही डिड नॉट हैव टू प्रूव ऑल दैट। वाई? बिकॉज उसका काम सिर्फ इतने से चल जाएगा कि मेरे पास फैक्ट्री है वहाँ पे और उसमें आग लग गई थी, एंड आई हैड गॉन एंड आई वेंट इनटू नाइट ओनली एंड इन द मॉर्निंग आई वाज देयर, सो दैट वाज सफिशिएंट टू प्रूव. What they are writing in this section, if you read the last part, are relevant in so far as they are necessary for that purpose. So these facts are relevant in so far as they are necessary for that purpose. Now, so far as necessary for that purpose, what they are suggesting, that you have to prove only as many facts as are necessary to serve the purpose of this section. उतने से अगर काम चल जाता है तो उसके अलावा और एक्स्ट्रा प्रूव करने की जरूरत नहीं है. If that much is sufficient, then you don't need to prove anything more than that. Now here, how much is necessary for reverting the inference? Only that I have a factory, the factory was on fire, and I was there on next morning, so that you can prove that I left in the night itself. So that much is sufficient, and therefore any further details need not be proved. Now next is, इसी एग्जाम्पल में these two persons are staying nearby, A and B. अब A के घर में theft हो गया, and there is B was found absconding. A के घर में मान लो 2 करोड़ रुपए चोरी हो गए, ज्वेलरी एक्सेट्रा. अब after 5 days this B came back to home with a brand new Mercedes. So is this not supporting the inference? All of a sudden he becomes rich. Then will it not supporting the inference that he may have committed the offense? अब या तो वो प्रूव करे, अगर मान लो वो प्रूव कर देता है कि मेरी लॉटरी लगी थी, that he got the money from the lottery, या फिर कोई और फैक्ट प्रूव कर दे, जैसे कि मुझे मरने से पहले किसी ने वसीयत बनाकर इतने रुपए दे दिए, 4-5 करोड़ दे दिए, someone give me through will before his death. तो अगर ऐसा कुछ प्रूव कर देगा, now he rebut the inference. But if he does not able to explain from where he got the money from, then that is going to support the inference that he must have committed the offense of theft. अब next example, suppose there is a room, and in this room A and B are sleeping together in the night, and in the morning B is found to be dead. B has been strangulated. B का गला दबाकर मारा गया है. अब B मर गया, he was alone remaining in the room A. So there is suspicion upon A. So the fact that he was sleeping alone with the B in the room, the last scene together thing will apply, opportunity will apply, and the inference of this that is suggested is that A has committed the murder of B. Now in order to rebut that, if A proves properly that I have paralyzed, I cannot move, and B was my caretaker, मैं उस कमरे में रहता था, and I cannot even go to toilet, and my hands are not working, and I cannot even get up from the bed. Now tell me, is it not something that rebut the inference? Now these common sense things you have to think about. अब एक और एग्जांपल देखते हैं. Again there are two neighbors, A and B. One fine day in the night, B was found murdered in his house, and when the police came, A was found inside the house near the dead body of B. B का मर्डर हुआ है और जब पुलिस आई उसने A को B के डेड बॉडी के पास देखा और उसने A को गिरफ्तार कर लिया. अब the inference is that since A has found near the dead body, he may have committed the offense. And in fact it was found that the main door is locked from inside. The main gate is locked from inside. Then what is A doing there? जब दरवाजा बंद है तो दीवार जंप करके ही आया होगा. Then again it make it more suspicious. अब A के पास एक explanation है and the explanation is that in the night around 2 a.m. In the night around 2 a.m. I was sleeping in my room and I heard that the dog of B was barking very badly, and I got up because of that. And from outside only, I was trying to find out, but I could not see anything. And all of a sudden, there was a blood shot, and thereafter the dog stopped barking. The dog shouted and it stopped barking, and someone has shot the dog. And out of my zeal to help A, be a good neighbor, to help B, I rang the bell but no one opened the door, and then I jumped from the wall, and when I came inside, I found that B was lying there. B was lying there dead, and the dog was also lying there dead. And I, in order to see whether B was alive or not, I take him into the hospital. I came near B. So for taking him to hospital, I came near B, and for checking whether he dead or alive, I was checking him, and in the meantime the police came. तो अगर ये सारा इंसिडेंट अगर प्रूफ हो जाए कि डॉग की बार्किंग को सुनकर वो अंदर आया था और उसके खिलाफ अदर सर्कमस्टेंशियल एविडेंसेस नहीं है, then in that case will we not A be acquitted? Will you not acquit A from the charge of murder? Is it not his presence on the spot is sufficiently explained by the fact that the dog was barking and B went there to see as to whether A went there to see as to whether B मरा है ना इसमें, तो to see whether, so B मरा है तो A went there to see whether any wrong committed there or not. अब इसी को आप रिवर्टल का पॉइंट भी मान सकते हो. अब इन्फ्रेंस क्या निकाल सकते हो इसमें, that since he was alone with the dead body, so he has committed the murder. And now it is proved that since he came from the dog barking and he was near the body to help him, so this inference is rebutted by this fact. तो जो फैक्ट रिवर्टल का फैक्ट होगा ब्रॉडली वही फैक्ट एक्सप्लेनेशन वाला फैक्ट भी माना जाएगा. So this is you meant by something which is explained. So if there is any circumstance which is going against you, but if you can somehow prove an explanation to explain that circumstance, then in that case you are benefit out of that, and that is where this section 9 will help you. Explanation. अब इंट्रोड्यूस के लिए एग्जाम्पल देखिएगा. व्हाट इज मीन बाय फैक्ट इंट्रोड्यूस अनदर a fact which introduce another fact. It means any fact which lays down the background. जब कई बार क्या होता है कि इंसिडेंट हुआ, an incident has taken place. अब in order to provide some rationality, trustworthiness or believability to comprehend the circumstances better, there will be some surrounding circumstances which you may call introductory circumstances. उनका उस केस से ज़्यादा बहुत कोई इम्पोर्टेंट रोल नहीं है, लेकिन वो सर्कमस्टेंसेस कहीं ना कहीं जो सर्कमस्टेंसेस हुए हैं उनके होने को पॉसिबल बनाता है. दे ड्रॉज अ बैकग्राउंड इन विच द अदर सर्कमस्टेंसेस हैपेंड. कोर्ट में कभी भी कोई विटनेस आएगा, सपोज अ विटनेस कम्स टू द कोर्ट एंड ही गिव्स द टेस्टिमनी दैट 3 a.m. in the morning I was going in front of that place where I saw that A killing B. A ने तो देखा ही है तो B killing C. अब the court can take the evidence directly also. अब he is giving the testimony of what? Fact in issue. That he saw A killing B. B killing C. And there the court, maybe in order to understand his trustworthiness, the court may ask the preliminary questions. For example, who are you? What is your name? आप रात के 2 बजे वहाँ पर क्या कर रहे थे? उस पर्टिकुलर प्लेस पर 2 बजे आप क्या करने गए थे? So witness may tell that I was walking, या फिर gone for something. Maybe there is a hospital nearby. For that I was passing by because I was ill. Or maybe I was returning from somewhere in the late night. So this is how it would be trustworthy if he explains and if he proved by other evidences that statements of this circumstance introduces the fact that he may have present on the spot. So there are some preliminary facts which happened and which lay the background upon which the main incident happened. Whenever a witness goes to the court, then the court will always normally ask some preliminary questions so as to introduce that certain facts may have happened. The court मतलब party may ask some preliminary questions that certain facts may have happened. और after that the main facts पर question शुरू करेगी party. Now these preliminary questions are related to the preliminary facts which are called the introductory facts. अब ये आपको illustration से और भी ज़्यादा clear हो जाएगा. This is for introductory fact. Suppose एक व्यक्ति एक बहुत गरीबी में है. He is in extreme poverty वाला condition because of some reason he is not having money. So he is in extreme poverty. He needs money as a help, and therefore he take loan for himself. He take loan from someone. A loan is not paid back by him. When the other party files suit against him, this person refuses to give the money, and the suit is filed. The court may ask question and may represent the fact at that point of time, and he is saying that I have not taken the loan. The fact that at that point of time there was an urgent need of money for him, that will be proved by the circumstances, and that introduces the fact that he may have taken the loan. That is not sufficient to prove the fact, but that is not sufficient proof of the fact, but simply introduces the fact that he may have taken loan for someone. Now, illustration A. The question is whether a given document is the will of A. The estate of A's property and of his family at the date of the alleged will may be relevant facts. Why? Now the question is whether A created that will. वो वसीयत A ने बनाया. अब at the time when he make the will, उस समय what was the stage of his family, what was the stage of his property, whether that property was included in the will or not. So will that not be relevant to introduce? Will not that be relevant to introduce that it may be that he has made the will? So here it will be relevant because it is an introductory fact. अब सपोज मान लो आपके पास गाड़ी नहीं है और वसीयत में आपने गाड़ी भी दे दिया किसी को. It means what? Because you do not have the car, it may not be your will. So जो प्रॉपर्टी आपके पास है उस प्रॉपर्टी को आपने वसीयत में लिखा है. So the fact that you had the property at that time and you may have made the will of that introduces the fact that you make a true will. Now A sues B for a libel imputing disgraceful conduct to A. B affirms that the matter alleged to be libelous is true. B का कहना है कि जो मैंने बोला है वो सच है. जो defamation matter is true. B कह रहा है. The position and relations of the parties at the time when the libel was published may be relevant facts as introductory to the facts in issue. अब मान लो आप प्रूव कर दो कि उस समय दोनों का झगड़ा चल रहा था. At the time when B makes a publication, at that time B and A were in dispute, and there was quite likely that B may have made a defamatory publication. अब B और A का झगड़ा चल रहा है. B ने एक defamation publication कर दिया A के खिलाफ, and B is saying that no, my intention was not that, and so forth. अब उस समय जिस समय publication किया था So उस समय it may be quite possible that you may make such defamation, may make such a publication, and therefore that may make making of a defamatory publication quite possible. अब आगे देखिए, is accused of a crime. Is accused of a crime. The fact that soon after the commission of the crime he absconded from his house is relevant under Section 8 as conduct subsequent to the affected by facts in issue. The fact that at the time when he left home he had sudden and urgent business at the place to which he went is relevant as tending to explain the fact that he left home suddenly. The details of the business on which he left are not relevant, except insofar as they are necessary to show that the business was sudden and urgent. वो जो फैक्ट्री वाला फायर फैक्ट्री वाला जो एग्जाम्पल था, फायर लगी तुरंत निकला, और बाद में ये कि डिटेल्स उसमें कितने वर्कर्स वगैरह काम करते थे ये बताना जरूरी नहीं, कितनी इनकम वगैरह ये बताने की जरूरत नहीं है. अब ए सूज बी फॉर इंड्यूसिंग सी. ए सूज बी फॉर इंड्यूसिंग सी. बी ने सी को भड़काया था कि ए के साथ तुम्हारा जो कॉन्ट्रैक्ट है उसको तोड़ दो. ए एंड सी वर इन द कॉन्ट्रैक्ट एंड बी इंस्टिगेटेड सी टू कमिट द ब्रीच ऑफ कॉन्ट्रैक्ट. दैट इज द केस. A sues B for inducing C to break a contract of service made by him with A. C on leaving A's service. C ने जो A की सर्विस छोड़ी उस समय says to A, I am leaving you because B has made me a better offer. अब this goes to explain that why C leaves the job of A. Why? Because B made a better offer. This statement is a relevant fact as explanatory of C's conduct, which is relevant as a fact in issue. अब C का जो कंडक्ट है नौकरी छोड़ने का वही तो मेन फैक्ट है. अब तुमने B के ऊपर सूट क्या किया है? A ने B के ऊपर सूट इसलिए किया कि that you instigated my employee to leave the job. अब here C's statement that to A that I am leaving your job because B is making me a better offer, is it not explaining that as to why he leaves the job? So that is an explanatory fact because it is explaining why she leave the job. So that is an explanatory fact. Now A accused of theft is seen to give the stolen property to B. A accused of theft is seen to give the stolen property to B, who is seen to give it to A's wife. B says as he delivers it. A says you are to hide this. B's statement is relevant as explanatory of a fact which is part of the transaction. अब देखो यहाँ पर स्टोरी क्या है. ए ने चोरी की, चोरी का सामान दे दिया बी को और कहा कि जाकर तुम इसको मेरी वाइफ को दे दो. बी जाकर चोरी का सामान ए की वाइफ को देता है और कहता है कि ए ने कहा है तुम उसको छुपाओ. अब दिस चोरी and giving this property to B and B is giving property to A's wife. That is all a part of same transaction or not? When the B says that A asked you to hide this, that they are saying that statement is explaining as to why he gave the property to wife of A, because A has asked him to give and to hide. A accused of theft is seen to give the stolen property to B, who is seen to give it to A's wife. B says as he delivers it. A says you are to hide this. B's statement is relevant as explanatory of a fact which is part of the same transaction. What fact? The fact that he given the property to the wife of A. क्यों उसने प्रॉपर्टी दिया? क्योंकि ए ने कहा था उसको देना और कहना कि तुम इसको छुपाओ. Now F, A is tried for a right. A is tried for a right and is proved to have marched at the head of the mob. And is proved to have marched at the head of the mob. The cries of the mob are relevant as explanatory of the nature of the transaction. अब कई बार आप जब जुलूस में निकलते हो तो कई बार शांति से निकलते हो, कई बार जोश में, मारो तोड़ो। अब ए आगे आगे चल रहा है और जो पीछे लोग हैं वो कह रहे हैं कि ए तुम संघर्ष करो, हम तुम्हारे साथ हैं। और एक हो गया नॉर्मल जुलूस जो शांतिपूर्वक ढंग से चल रहा है। और एक मॉब ऐसा है कि जो बोल रहा है ए आज पीछे मत हटना, आज मार के रहेंगे, मारेंगे या मरेंगे। तो इस तरीके कोई स्लोगन चल रहे हैं। अब बताइए, इज दैट नॉट एक्सप्लेन्स दैट द मॉब इज नॉट पीसफुल? मॉब इज नॉट पीसफुल. So the cries of the mob, the slogans of the mob are relevant as explanatory of the nature of the transaction. Nature of the transaction means what was the nature of the mob, means whether it was actually a rioting mob or a peaceful mob. तो जो sloganing हो रहा था, that was explain the nature of the group of people. So that's it for this topic in this section 9. And we had over by this section 9, and in next lecture we would continue with section 10. Thank you for watching lecture.